3.
Hi, welcome back. We're going to go through the Divorce Act now. The Divorce Act is one of 3 or 4 acts that affect you when you're getting divorced. Matrimonial property is another one, we'll go through that too. Children's Act, we'll go through quite a lot of that. And the Maintenance Act, that's the other main one. But the Divorce Act is relatively short, but it lays the foundation for everything that comes after. Now, a lot of people, if they're not lawyers, are quite intimidated by reading acts, but actually anyone can read an act, and a lot of it is going to be quite straightforward. And the bits that aren't straightforward, that involve a lot of legal terms and stuff, I'm going to explain to you. So you're going to become very familiar with this act, you're going to become very familiar with the other acts, and that's going to be the basis for your knowledge. Okay, so let's just start. Like all acts, just about all acts I think, it starts with certain definitions. So, court means a high court as contemplated in section 166 of the Constitution of the Republic of South Africa, or a court for a regional division contemplated in section 29(1)(b) of the Magistrates Court Act 1944, which is jurisdiction with respect to divorce action. Now, what does that mean? It means if you want to get divorced, it used to be you could only go to high court, because high courts dealt with matters of status. Very sensibly, they realised that having to employ advocates in the High Court, even though it was a fairly cheap thing compared to other things, was not really necessary for a divorce. So a few years ago, legislation was passed that allowed regional courts, which is part of the Magistrates Court, the upper part of the Magistrates Court, the most senior part, to hear divorces as well. So nowadays you can get your divorce done in regional court, which is generally cheaper because you can use attorneys. You don't necessarily even have to use advocates unless there's complications. So that's what we mean when we say courts. We can either be a high court or it can be a regional court. Divorce action means an action by which a decree of divorce other than relief or other relief in connection therewith is applied for. So divorce action basically means any kind of divorce which you've applied for. An application pendenti liti for an interdict or an interim custody of or access to a minor child of the marriage concerned or for the payment of maintenance. So an application pendenti liti means it's pending. So if it's for an interdict, that's to stop something, maybe to stop a child leaving the country or to stop somebody disposing of their assets, that can also be heard. So in a regional court or the High Court. So that divorce action includes that kind of thing. When we use the phrase divorce action later on, that will include that kind of thing. Access to a minor child of the marriage, that also is included in the phrase divorce action. Or even for the payment of maintenance can also be considered part of a divorce action in certain circumstances. You can actually, of course, apply for maintenance when you're already divorced or when you've never been married, but it can be part of a divorce action too. An application for a contribution towards the cost of such action or to institute such action. So that's when somebody's saying, I don't have any money to pay my legal fees, please can my ex-spouse pay for the costs of this. You can make an application to the court for that. Or make such an application in forma pauperis. Now that's how it comes from the word pauper, which means you're poor and you can't afford things. Doesn't mean you actually have to be a pauper living in the street, but you can't be taking your BMW to Santon top restaurants and then be claiming that you're a pauper. So you have to actually be poor to claim this. Or for the substituted service of a process or in the edictal citation of a party to such action or such application. What these things are, substituted services, if you can't find the person, if they've disappeared and you're trying to serve them with the court documents. If they're in South Africa, substituted service is how you do that. We may go into that later on, I'm not sure. Or the edictal citation, which is when the person's in another country. You know where they are, but they're in Britain or Australia or whatever, and you need to serve them with papers there. This is not common in divorces. You do get it, but it's not the most common thing, so we're not going to focus on that kind of thing. But I want you to, by the end of this, you can read through the Divorce Act and go, oh yeah, that's about serving people in another country, you don't need to worry about this. So I'm just, so that you don't read through the Act and get confused with all these terms. By the end of this, you should read through the Act and go, okay, I don't need to know about this, I don't need to know about that, but I understand what it's about, and understand the Act. Pension fund means a pension fund. By the way, maybe I'm using the most up-to-date version of the Divorce Act, obviously. It's copyright to the people that put this together and made all the updates. So the one that you actually get in the package, I can't use their one because it's copyright. So you'll get one that's freely available on the internet. It might differ slightly. Where it differs, my version prevails. But mostly it's the same. Pension fund means a pension fund as defined in Section 1.1 of the Pension Funds Act, irrespective of whether the provisions of that Act apply to pension funds or not, to the pension fund or not. Right? So there's all kinds of rules, and we probably will go into them at some stage, about what happens to pension funds. So if you've got a matter in your divorce where you or your ex-spouse, or your spouse, ex-spouse to be, let's say, has a pension fund, then you need to know about that. But I'm not going to address it here. I'll address it in a separate video at some stage so that people that don't have pension funds aren't kind of bogged down by all this complicated stuff about pension funds. And the most complicated thing is this thing, pension interest, which is the next definition, which I'll skip actually because I'll do that when I do a lecture on pension funds. I have been involved in a case, a divorce case, or a case related to divorce that revolved around this pension interest matter, but it's extremely complicated, so I'm not going to go into it now. Rules, that's related to pension funds. Right, so that's all the definitions, which is quite good because some acts have definitions that go on for much longer than this, but this one's relatively short. So we can get into the meat of the Act now. So Section 2, for the purposes of this Act, a divorce action shall be deemed to be instituted on the date on which summons is issued, or the notice of motion is filed, or the notice is delivered in terms of the rules of court, as the case may be. Okay, so when you bring legal action in general, you can bring it in two ways. You can bring it as an action, that means it's a summons and there's a trial. Or you can bring it as an application, which means there's a notice of motion and an affidavit, and then there's a hearing, there's not a trial. The application method's usually quicker because everything can be decided on the papers. So there's no trial, there's no witnesses, there's no people being cross-examined. That happens in an action, which goes along with the summons and the trial. Summons is the document you use to start it, and then there's ultimately a trial with witnesses and cross-examination and the way you think of a trial. Most things are actually brought by application, which means there's just a notice of motion that says what you want. There's an affidavit which gives you all the facts and the evidence for these facts, and everything is done on the papers. So that's the difference with these two things. You don't need to know much about it at the moment. Just that there's two different ways. Now, whenever you serve that notice, whenever you issue that, which means you've served it, you've filed it, you file it in court. So you take it to the court, you give it to the registrar or the clerk, and he or she opens the file and places it on the court record. You also serve it on the other side. So your ex-husband-to-be or your ex-wife-to-be, you've got to take one to them. Usually, you get the sheriff to take it to them. And then you can prove, you see, with the sheriff's return that they've got it. So that's what this means. And the date that your divorce action starts is when that summons is served and filed. Issued means served and filed. So it's being delivered to court, it's being delivered to your ex-spouse-to-be. Whether it's a summons or it's an application, that document is in court, it's with the other person. That's when you've instituted your divorce. That's the date of institution. Right. So that was section 1, subsection 2. We're now in section 2, jurisdiction. Now, jurisdiction means which court should it be in, basically. That's what it means. So a court can only hear a divorce if it's got jurisdiction. If you take your divorce and file it somewhere where you're not living, you've never lived, your spouse doesn't live, you don't live, they're not going to be able to hear it. There's got to be a reason why you file it there in that court, and that's what we're going to talk about in this paragraph. A court shall have jurisdiction in a divorce action, and we've just found out what a divorce action is, if the parties are or parties is domiciled in the area of jurisdiction of the court on the date in which the action is instituted. Now we know from before what date the dated institution of the action is. Right? Now domiciled kind of means living in, it's slightly more complicated than that, but in ordinary terms, basically if you're living in the area of the court, or if your ex-spouse to be is living in the jurisdiction of the court, then either of these things is fine. Now that differs from how normal legal action takes place. Normally it's where the defendant lives, it's not where the plaintiff lives, the person who's starting the action. It's the defendants, where they live, that determines jurisdiction. And there's various other ways of determining jurisdiction, like where the cause of action, like where the thing happened. Like if there was a car crash in Durban, you can bring it in Durban even if you live in Sandton and the other person you crashed into lives in Cape Town. You can still bring it in Durban if you want, because that's where the thing happened. But with divorce actions, it can be where either of you are domiciled, which means live, or in B, ordinarily resident in the area of jurisdiction of the court on the said date when you started the action, and have or has been ordinarily resident in the Republic for a period of not less than 1 year immediately prior to that date. So domicilium and ordinary resident are different concepts, but they're very similar. I'm not going to go into them in depth, because in 99% of divorces it's going to be very clear where you can bring it. You can bring it basically where you're living or where the other person's living. If you want to do the ordinarily resident one, then you've got to also have been in the Republic for no less than a year. Normally this kind of thing isn't a problem. But if you have, you need to kind of know this, so that if you do have, it's just a tick box to check, and so you know where to bring it. But the big advantage of this, as compared to most other court cases, is usually what will happen is you'll bring it where you live. If you're bringing the action, if you're bringing the divorce, you'll bring it where you live. And if the other person's living in another city, that'll be very inconvenient to them. Normally you can't do that, you can with divorce. A court which has jurisdiction, in terms of subsection 1, which we just read, shall also have jurisdiction in respect of a claim in reconvention or a counter-application in the divorce action concerned. Right, so what that basically means is, if the other person comes back and it goes more than replying, but makes a counter-claim against you in some way, so they're not just responding to your papers, they're bringing something else against you, then that court will also be able to hear that same matter that's kind of connected with your matter. And it wouldn't, without this section 2, subsection 2, you wouldn't normally be able to do this, because if you brought a counter-claim and the jurisdiction of the court was not where the other person lived, then you might have to change it. But here with a divorce, it's fine. You can bring your counter-application, or they can bring their counter-application against you, and it's the same court can hear both. Just kind of convenient anyway. 3, subsection 3, a court which has jurisdiction in terms of this section, in a case where the parties are, or either of the parties is not domiciled in the Republic, shall determine any issue in accordance with the law which would have been applicable had the parties been domiciled in the area of jurisdiction of the court concerned on the date on which the divorce action was instituted. So if anybody leaves South Africa, then the law that will apply will be the law which would have been applicable, probably South African law, had the parties been living, basically, in the jurisdiction of the court, within that court, on the date where the divorce action is instituted. So basically what it's saying, to cut all the language down, it's saying South African law will basically apply to your divorce. That's basically what it's saying. So regardless, if somebody else is going to live in Australia or England, Australia or English law won't apply. It doesn't come into it. If you file a divorce in this country, then it's South African law that's going to apply. The provisions of this act shall not derogate from the jurisdiction which a court has in terms of any other law or the common law. So in other words, this isn't restricting the jurisdiction of the courts, it's expanding it. And so if court is jurisdiction in terms of some other law, the ability to hear a case, that is jurisdiction, then it can still hear that case in terms of the other law that applies. That probably won't apply to you, but right, a very important section here, section 3, dissolution of marriage and grounds of divorce. Dissolution of marriage means basically the marriage is made null and void, it's no longer That's basically divorce. So a marriage may be dissolved. Dissolution basically means dissolving by a court by a decree of divorce, and the only grounds on which such a decree may be granted are the irretrievable breakdown of the marriage, as contemplated in section 4, which is the next section, or the mental illness or continued unconsciousness, as contemplated in section 5 of the party to the marriage. So the first one, irretrievable breakdown, is by far the most common grounds of divorce. But you do need to be aware, in case the circumstance is your circumstance, that mental illness or a person's in a coma and they're unconscious for a long time is also a grounds for divorce. But it's very rare. I've never done a divorce on that ground. Now it says that it's the only grounds, but it's a very wide grounds, because basically it means if anyone says that a marriage is broken down, either of the parties irretrievably broken down, as long as they can show that, which is quite easy to show, then you can get a divorce. And I've even been involved in a case where my client, who was the guy, didn't want to get divorced. He said no, he doesn't agree to any divorce, he wants to stay married. But the law in this, unfortunately for him, is that if either party wants to get divorced, the court won't make the party that doesn't want to stay married, unless, as we'll go on to see, unless they think there's scope for the marriage to recover. But if there's irretrievable breakdown, even if one person doesn't want to get divorced, the court will grant the divorce. Right, section 4. Irretrievable breakdown of marriage as a grounds for divorce. This is the main one. This is the one you'll probably use in yours. A court may grant a decree of divorce on the grounds of the irretrievable breakdown of a marriage if it is satisfied, and when you're sitting in court, whether it's opposed or unopposed, this is what the judge is thinking. Has there been an irretrievable breakdown? And before we go on, let me tell you a slightly funny story of one marriage. Basically, if you go to court and you've been separated, they'll ask you how long you've been separated for, and any good advocate or attorney will tell the judge before he has to ask how long they've been separated for. So if you've been separated for a year at least, let's say, or even 2 years, certainly the judge will say, okay, it's irretrievably broken down. However, I had one client and they'd only been separated for 2 or 3 months. So I got up and I was taking the judge through the stuff, and I said, how long have you been divorced for? And he said, how long have you been separated for, sorry? And they said, oh, we've been separated for about 2 or 3 months. And you can see the judge stopping and saying, oh, only 2 or 3 months, that's a red flag there. And so I had to cover that. Obviously, I thought of in advance. And I said, and what exactly does your ex-spouse do these days? And he said, well, she's actually a naked dancer at teasers now. And the judge just turned and said, okay, divorce granted. So the fact that it was only 2 or 3 months was outweighed by the fact that his wife was now working at teasers, and he wasn't the kind of guy who would have encouraged that or thought that was okay. So, the key thing is, has there been a irretrievable breakdown? And in that case, that constituted a irretrievable breakdown of the marriage. And it wasn't difficult to persuade the judge. Okay, so a court may grant a decree of divorce that satisfies that the marriage relationship between the parties to the marriage has reached such a state of disintegration. This is what he's looking for, that there is no reasonable prospect of the restoration of a normal marriage between them. So generally in an unopposed divorce, if you just say that, that's enough. The advocate will say, or the attorney will say to you, will say, do you, because in divorce, generally speaking, there's sometimes you can do it just on affidavits if everybody agrees to everything, there's no children, etc. But most of the time, you're actually in the witness box, and in an unopposed divorce, you're in the witness box for about 5 minutes. Really, I mean, you sit in that divorce court and you go through 50 in a day, in the morning, it's like 5 minutes, next. And it's quite an automatic process. Most of them are granted. Now and again, you get one that isn't. Maybe there's things on the papers that haven't been, like technicalities, for example, you've always got to bring your certificate of marriage and prove that you're married. And sometimes people forget to do that, and then you can't be divorced if you can't prove you're married. So, have to remember to bring that. But any decent lawyer will make sure that that's in the papers. And so, as long as there's no prospect of a restoration of a normal marriage between them, So subsection 2, subject to the provisions of subsection 1, which we've just gone through, and without excluding any facts or circumstances which may be indicative of the irretrievable breakdown of the marriage, the court may accept evidence. We'll go through the things that it might accept. But it's saying this isn't the only things you can consider, but these are things that might be worth considering. A, that the parties have not lived together as a husband and wife for a continuous period of at least 1 year. So that's what I just said. Immediately prior to the date of the institution of the divorce action. We worked out how to work out that date earlier on. So if they haven't lived together, that's kind of indicative that they're not together. So if you can say, yes, we've been not together for more than a year, then the judge is going to take that as fulfilling that condition. B, that the defendant has committed adultery and that the plaintiff finds it irreconcilable with the continued married relationship. Now this is a bit of a subtle one because we have, like many countries since the early 70s, late 60s, we've switched to a no-fault divorce system, right? So before that, and in some countries still to this day, in order to get a divorce, you've got to prove fault. You've got to prove that the other side did something wrong, like had an affair or something. We don't have that system. As long as if the marriage is irretrievably broken down, in a way it doesn't matter, and the judge doesn't really want to hear that there's been an affair or adultery or whatever. But for this purpose, if the person has committed, the other person or you or whatever has committed adultery, actually it's only the defendant, it says. It's not, you can't, as the plaintiff, the one bringing the divorce, say, I committed adultery and my partner isn't happy with it. It's got to be the other person. So if you're going to use that condition, then if it's you that's done it, then the other side has to sue you for divorce. And the plaintiff files it irreconcilable. You could have situations where the plaintiff says, no, actually, although my partner's committed adultery, I don't find that I can take them back. So it's got to be, it's not just the adultery, it's also that the other side finds that causes an irretrievable breakdown, that it's irreconcilable with continued marriage relationship. And C, that the defendant has, in terms of a sentence of a court, been declared a habitual criminal and is undergoing imprisonment as a result of such sentence. So again, not very common, but if your partner has been incarcerated in jail, then that's pretty much grounds for a divorce. I hate it when that happens, every time. So these three things, the court may accept. If it chooses to, it's got discretion, it may accept. It can use these as proof of the irretrievable breakdown of the marriage. Right, now listen to this subsection 3 though. If it appears to the court that there's a reasonable possibility that the parties may become reconciled through marriage counselling, treatment or reflection, the court may postpone the proceedings in order that the parties may attempt to reconciliation. Okay, so if the court says, okay, you've only been separated for 2 or 3 months, doesn't sound from what you've been saying that it's completely broken down, let's postpone. So they don't dismiss your divorce, it still remains in court, it's still there, it's just been postponed. So later on, if the court postpones it for 6 months or a year, after, if it doesn't work, you can just come back and you don't need to file all new papers. You just come back and say, okay, we want to set this down again, which means we want to get a date and we want to be heard by the court again. And the judge this time will say, okay, we tried, and generally speaking, we'll say, okay, we'll grant you the divorce this time. And subsection 4, when a divorce action is not defended, which is not defended is postponed, in terms of the last section, subsection 3, the court may direct that the action be tried de novo on the date of resumption thereof by any other judge of the court concerned. So, if it's postponed, the court can decide that the action be tried de novo. De novo means of new. It means that you kind of start again and you do a completely new trial. So the judge can say that if he wants. So it doesn't have to come back with the same papers, but it can. Okay, so that's the first section of the Divorce Act. We will now be continuing in the next section with the next sections of the Divorce Act.